This is in the matter of the people of the state of Michigan versus Jamie Lee.
All right, folks, buckle in. We're in Michigan court today for the sentencing of Jamie Lee Curtin. This isn't your run-of-the-mill case. It's a gut punch mix of drug addiction, child endangerment, and legal nuance. Pay close attention. Every number, every guideline calculation here matters more than you think.
Pardon. We have files number 22-20792FH, 22-21124FC. I have David Goldstein appearing on behalf of Ms. Carden. I have Douglas Hartung and Jacqueline Weiss appearing on behalf of the people. This is the date and time set for sentencing in this matter. Mr. Goldstein, I was handed a victim impact statement this morning from one of Ms. Carden's daughters. Just a reminder for purposes of this hearing, you need to make sure that you use initials and not minor children's names. All right. Did you receive a copy of the pre-sentence investigation report?
The corrected one, yes, Your Honor.
All right.
Okay. I'm sorry, Your Honor. On page, there's one thing on page 9, where it talks about marriage narrative. It indicates that there are it says here that there are 3 children with Chris, not Chris's daughter.
Okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Probation Department has computed the minimum sentencing guidelines on file number 22-20792FH, count 1, police officer fleeing 4th degree, to be 2 to 17 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
Ms. Weiss?
Yes, Your Honor.
On file number 22-21124FC, count 1, assault with intent to commit great bodily harm less than murder, the probation department calculated the minimum sentencing guidelines to be 34 to 67 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
Ms. Weiss?
Yes, Your Honor.
Okay. And then on file number 22-21124FC, count 2, child abuse.
And here's our first curveball. The defense is pushing to erase a marijuana conviction from Carden's record. Why? Because Michigan's laws changed. But legally, that past conviction can still weigh into sentencing if it was a crime at the time. This is a classic example of how the law often lags behind cultural shifts and why judges still have to play by the rules in place on sentencing day.
For first degree, the probation department calculated the minimum sentencing guidelines to be 135 to 225. Do you agree with that calculation of guidelines?
1 second, Your Honor. I circled PRV 5, and now I got to remember why I did that. So just give me 1 second.
Okay.
That would be prior. I believe PRV 5 is prior misdemeanors. Your Honor, I think the reason I circled it was that one of the prior misdemeanors was a possession of marijuana charge. And I know that in some courts, that's no longer considered a conviction. Other courts take the position that it was a crime at the time, and so that doesn't change as far as prior record is concerned. But my understanding from a lot of literature since Michigan legalized marijuana, that they no longer consider possession of marijuana to be a criminal conviction.
You're saying PRV 4?
I'm sorry, I've got it circled PRV 5.
Oh, Mr. Goldstein, at this time, it's still showing up as a conviction, and it may very well get set aside, but at this time, I'm gonna leave it on the screen.
Well, Your Honor, my understanding is that the state took an action some time ago to eliminate all possession of marijuana convictions. I realize you'll find it if you look, it's certainly there, but my understanding is when they changed the law, that they went in and basically wiped out all possession of marijuana cases.
They're working on that. Does it change the guidelines?
That's what we're looking for.
I just asked. No, Your Honor,
It doesn't change.
All right. So any objection, Ms. Weiss?
No.
All right. So we will mark that as 0. Anything else for the guidelines?
No, Your Honor.
All right. Ms. Weiss, do we have anyone here that's going to speak today?
I do. Do you want me to call her TC, or do you want me to state her name for the court?
You can use her initials.
Okay, I do have TC here to speak.
Do you want someone to read your statement for you? Would that make it easier? Thank you very much. The record should reflect that I was provided a victim impact statement this morning, and that I was able to hear the young woman enough to state that everything she said was in that victim impact statement. Is that correct, Mr. Goldstein and Ms. Weiss?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Anybody else?
No other victims.
All right. So you were very brave, and I'm very proud of you for being able to get up there and do that. All right, Mr. Goldstein.
This is a pivotal defense strategy. Frame Carden not as a monster, but as someone swallowed whole by addiction. Notice the lawyer's language. Not accused of doing things, but of not doing things. That's legal shorthand for omission. Liability? It's a hard sell when children are the victims. But in law, intent and capacity can heavily sway punishment.
Ms. Weiss, do you want to reserve a statement after, or would you like to make your statement now?
Yes, Your Honor, I'd like to reserve my statement.
All right. Mr. Goldstein, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. This is a fairly unusual situation in that you cannot deny that certain things happened. There's no question that they did. But this is not the person, meaning Ms. Carden is not the person who did those things. That's not what she's accused of. She's not accused of doing things. She's accused of not doing things, which is not protecting her children. The context of this, Your Honor, is that my client is not an evil or a bad person. My client was gripped by an incredibly intense addiction to drugs. The pre-sentence report indicates not only the amount of drugs that she was doing, but the type. She was doing cocaine, she's doing morphine, she's doing heroin, she was doing alcohol on a daily basis. Some of them starting from when she was 13 years of age. And the problem, Your Honor, is that never having been a drug addict, I think it's hard for me to understand, and I think anyone who's never been a drug addict to understand the power and the control that hard drugs have over someone's life. As the court is well aware, having read the reports and having heard the plea, my client was allowing other individuals to do things in order for her to feed her habit. Now, I'm not excusing what she did. I'm not trying to justify what she did. I'm trying to understand what she did, why a mother would allow this to happen to her children. And again, I don't think I can answer that question, at least not for myself, because I've never been a drug addict. I don't know what that's like. I've never been addicted to alcohol. I've never been addicted to heroin, cocaine, etc. So I don't know what that feels like, but it must be awfully strong and awfully powerful to have created the situation that was created in this particular case. So I'm not asking the judge, the court, or anyone else to pat Ms. Carden on the back and say, you were a good mother. No, what I'm saying, try to understand what she was going through and understand that if it had not been for the drugs, this probably would not have happened. And so what the court should be looking for, yes, there has to be some punishment. My client understands that. But there also has to be some understanding that this is not an evil person that needs to be locked away for the rest of her life. What she needs is rehab, treatment, and help in breaking that addiction. Now, certainly, having spent the last 540 some odd days in jail, she is probably drug-free right now. But we need to understand that there's an attraction out there that's going to grip her again once she gets out of prison, if we don't address that issue. So I'm asking the court to give her the lowest sentence the court feels is appropriate.
Ms. Carden, is there anything you'd like to say on your own behalf?
First and foremost, I would like to take.
Okay, so hold on a second. Mr. Goldstein, could you perhaps move the microphone down a little bit? Ms. Carden, take a deep breath and then make sure you speak loudly enough that we pick it up on the microphone, okay?
First and foremost, I would like to take the time to apologize to my children, family, of course, for all the pain and suffering I have caused. The time I have taken away from people, not only during my incarceration, but also prior to that because of my addiction. I'd like to throw myself at the mercy of the courts during my sentencing. Your Honor, as you see, I have a severe addiction problem. After 16 months incarceration, I can finally admit I want and need help. I feel prison doesn't help people with addictions, mental health problems. I'm begging for a second chance at life. I'd like to do a long-term inpatient dual diagnosis treatment center. I realize my mental health is my #1 trigger. I know it's a lot of work and recovery, but with the right support, I know I can and will do it. I'm 37 with a college degree and have never been in trouble before this. I can promise I will never get in trouble again as I have learned my lesson. I've already lost everything due to my addiction to choices I've made, including my children, my family, my career.
Twice.
Boom, here's the prosecution flipping the script. They're saying, nope, this wasn't just passive neglect. This was an active choice to put her kids near predators for personal gain. That reframe is devastating because it turns the defense's she couldn't help it narrative into she chose this path. In courtroom chess, that's a power move.
Your Honor, I know usually only one prosecutor speaks, but I'd ask the court to allow me to say my piece as well as Mr. Hartung. I would like to indicate for the court that we heard this morning that Ms. Cardin was convicted based on her failures to act instead of an act itself. Jamie Cardin was notified multiple times that Sam Compton and Ernie Black were sex offenders. It's not that she failed to protect them. She put them in situations to be around those sexual predators. She indicated she did that because she was getting money, vehicles, whatever she needed to feed her drug habit. That's not a failure to act. That's a willful act. Put your child in those situations. First time that I met the young lady that stood before this court to speak to you, she couldn't have even reached my shoulder. Over the years, I've watched her grow into a beautiful, strong young woman. And I've heard about the awful things that she's been through. So to suggest that this is just something short of evil, I don't agree with. And I'm asking the court to sentence the 12.5 to 40 years.
Mr. Hartung.
So because we allow this work in advance in terms of what we're doing today, in terms of the action.
Did you catch that? The prosecutor just compared this case to a Greek tragedy. And honestly, they're not wrong. You've got betrayal, irreversible harm, and a chain reaction of destruction sparked by a single flaw, addiction. The takeaway, in law and in life, one weakness can set off a catastrophic chain of events.
Numbers of sentencing. The court's choice today is somewhat limited on these matters. And the court was really deciding, I believe, decide on the bottom end of the sentence for the child abuse charge between 10 years and 12.5 years. And the very thorough, very concise report compiled by Jennifer Walsh lays out very, truly significant reasons why to follow her recommendation, which includes the 40-year cap, 40-year maximum cap on the top, and the 12.5-year recommendation on her part as well. And for the reasons what I'm saying, what the court has heard today, what Ms. Weiss has said, and what the victim has said, those are all very well supported. What I want to say directly is that the breadth and scope of the tragedy that was put in motion by Jamie Cardin's drug addiction borders on mythological Greek tragedies. Let's take a look at what happened here because she has a drug addiction. She basically sold her daughter for drugs. Her daughter was sexually assaulted because the defendant has a drug addiction. Because the defendant has a drug addiction, the victim's father, in cold blood, murdered 2 men and almost a third, and almost murdered the defendant. He testified as such at the preliminary examination that occurred in this case.
I'm sorry, you can't talk right now, please.
What Ms. Carden said was he tried to kill himself too.
He was doing a murder-suicide is what he was doing.
And that's all very accurate. The man that he didn't kill, hold on, the man that he didn't murder went to trial, Ernie Black. And the victim testified in that case. And the victim testified in the preliminary examination for that case. And she was strong, and she told the jury what happened. And Mr. Black was convicted of child abuse, criminal sexual conduct in the first degree. And because he had a prior criminal sexual conduct in the first degree or third degree, he is now imprisoned for the rest of his life without a chance for parole. This is the kind of victim that we have in this case. She is strong and she is courageous. And when it was time for Mr. Black to be sentenced, he had a letter written out just like she had today. And again, she had some difficulty at first. And I remember in the hallway, and she didn't want to do anything. So I said, "Are you ready to go in and bury this son of a bitch?" She went in, spoke with courage, just like she did today, and with a higher volume than she did today. This has gone on for a long while. Ms. Weiss is correct. It was first started out with Ms. Borders, myself, and Ms. Weiss. We have literally watched her grow up into a very brave young woman, all because of what happened. And I'm sure that's bittersweet from their perspective, probably sad from their perspective, because if she did not know Ms. Borders and Ms. Weiss and myself, she would not be here today, having had what happened. But she has emerged out of this much more than a survivor. She's a hero.
Thank you.
And I may make a few remarks after hearing this. Sure. As the court knows, I've known Mr. Hartung for many, many years. And I've always respected Mr. Hartung for, among a number of reasons, his professionalism. And that showed here today. Because when he addressed the court, he didn't say that all these terrible things happened because of my client. He said all these terrible things happened because of her drug addiction, which is exactly the same thing that I said to this court when I addressed the court a few moments ago. Jamie Carden is not a bad person. Jamie Carden doesn't go out looking to do bad things, but Jamie Carden had a terrible drug addiction. And that's where if you want to talk about blame, at least 80% or more of the blame rests with that addiction and not with Jamie Carden. Now, he also went on, one thing that I do disagree with that he said to the court, he talked about Chris Carden. And he somehow seemed to feel that Chris Carden only did what he did because of my client. And that's not true. You want to talk about someone who made a conscious choice to do something. Chris Carden picked up a gun and killed people and tried to kill this person standing next to me. And she's not responsible for what Chris Carden did, nor is her drug addiction responsible for what Chris Carden did. One person in this world is responsible for what he did, and that's him. The court can address him when the time, I assume, I don't know if you have it or Judge Olsaver does, but that will be addressed at the appropriate time. But this is the person, Jamie is the one being sentenced today, not Chris.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principal proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing.
There it is, 12.5 to 40 years for first-degree child abuse. That's the court's way of saying, yes, addiction is tragic, but when it leads to a child's suffering, accountability takes center stage. And remember, in Michigan, that top number is the max possible before parole, meaning Cardin could spend decades behind bars.
Criteria and reasons for the sentences are the nature and gravity of the offenses, the discipline appropriate to their commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. It is the sentence of the court that on file number 22-20792FH, you will be sentenced to the Michigan Department of Corrections for a period of 1 year, 4 months to 2 years with credit for 29 days. And that is on the fleeing fourth degree charge. Let's see, you will pay a crime victim assessment fee in the amount of $130, DNA testing fee in the amount of $60, and a $68 state cost. On file number 22-21124FC, on count 1, assault with intent to do great bodily harm less than murder or by strangulation. It is the sentence of the court that you will serve 5 years to 10 years with credit for 543 days with the Michigan Department of Corrections. There is a crime victim assessment fee in the amount of $130 and $68 in state costs. On file number 22-21124FC, count 2, child abuse first degree. It is the sentence of the court that you will serve a period of 12.5 years to 40 years with the Michigan Department of Corrections with credit for 543 days already served. There is a crime victim assessment fee in the amount of $130. Ms. Walsh, do I assess the $60 DNA fee on each file or just one? I think it's just one, isn't it? Just one, okay. During the term of your incarceration and parole, you will obey and comply with all the provisions required and engage in substance abuse counseling as well as mental health counseling. Is there anything else, Mr. Hartman, Ms. Weiss, or Ms. Walsh?
No, thank you.
All right, so Ms. Cardin, my bailiff is going to bring down to you two sets of your notice of right to appellate review. There's one set for each file. I need you to initial and date the top copy for our records to acknowledge that you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail them to the address listed on the form within 42 days. Ms. Walsh, the victim impact statement that was read on the record today, I want attached to the PSI. Okay. And to the young lady who spoke today, you can't pick your parents when you're a child. You can't choose who your parents are. You can't choose most of the things that happen to you, but you can choose the future you will have. And you're sitting there with some wonderful people who will help you do that. I wish you the best of luck. Thank you. Record should reflect I received.
Thank you, Your Honor.
Record will reflect I received back a signed copy of the notice of right to appellate review.